Welcome to another edition of Lawyer versus Lawyer. I'm Gary Berger. Hello, Debbie.
Hey, Gary. It's good to be back. How are you?
I'm doing great. Thank you. Debbie Champion, my co-host. Debbie, we do a lot of these things. What would you like to talk about today?
So what is this? October, our 10th month of essentially the post-COVID year. We've been trying cases more.
Yeah.
And I've been successful on some of these motions to strike punitive damages because of the new rule, I guess. I don't know if it's a statute or a rule, which says you have to first meet the bar of evidence, I guess, or information before you allege punitive damages. So I was interested in what you've been running into and what tricks of the trade you have when you want to allege punitives, but you can't yet till you prove things. So.
Well, that's a great question. I'm glad to talk about that. I just talked to a lawyer who bent my ear about this 2 days ago. I was walking my dogs and I told him all my thoughts. I shared a bunch of my thoughts on it. So, this is the same rule as Illinois has had for a long time. And it's kind of my practice too a little bit. So, the law in Missouri now is that you can't plead punitive damages right out of the box ab initio. You have to get a showing of evidence that would support punitive damages in litigation and then move to amend your petition for punitive damages. And that's the law in Missouri now as well.
I just looked it up. It's 510.261.
510.261. That's another tort reform. How have you been? Tell me about your motions that you've been filing on that issue.
Well, what it says in that statute under Section 5, it says the initial pleading in a civil case cannot contain a claim for punitive damage award. And so what you have to do is, if you do have a punitive damage award, I really think even in assault and intentional tort cases, you cannot plead punitives if you read the rule as it states. And so then you have to file a motion to strike the punitives. And so on the defense side, that's good because we get to knock that out initially until we can see whether the case can get settled. Because so many times you can't settle a case with punitive damages in it. You just cannot get them settled. And so that's good for the defendant. So
why can't you settle a case of punitive damage?
Oh, Gary, that's a whole nother podcast. But let me just say this. So when I'm representing a defendant who has some punitive acts, I have a number of different things that I have to address for the insurance company. And so some of those things are, is this an intentional act? Well, I'm not representing the insurance company, so I can't answer that question. But they are digging and trying to find the answer to that question, because if it is an intentional act, there's no coverage.
Right.
And then the punitive claim always runs into other potential coverage defenses.
Right.
And there's always, in my mind, a little bit of a stall when there's punitive damages, because somebody has to make the decision, does this kick in any sort of coverage issue? And secondly, different companies have different ways that they handle punitives. For example, I've got a case right now where we're trying to settle it. It's just an auto case. There's no punitive issue in it, but punitives are alleged, and the judge let them allege punitives. And so they've got punitive alleged, and they're doing what good plaintiff's attorneys will do, and they're trying to let the insurance carrier know, hello, you need to protect your insured because we have punitive alleged against them. And the insurance company has taken that to mean they can't mediate the case. And I guess they're thinking that they're settling out punitive damages and punitives aren't covered, and so the person who needs to settle the case is the defendant. Well, that's a weird way to think about it, but it just complicates the settlement process.
Unnecessarily?
It depends whether it's unnecessarily, depends on the facts, but it for sure slows it down, for sure.
Yeah.
And so I like this statute only because of that. It kind of makes the plaintiffs jump through two hoops, but you can always jump through that hoop.
And for the right case.
Yeah.
I don't mind, in terms of tort reform that can come our way, this one doesn't bug me.
Yeah.
On the plaintiff side, because to me, you want to keep your powder for the right case, right? Certainly you can do punitive damages, and you should, but not in every case, not for every car wreck case, right?
Right. And there are some people who every time filed a punitive case. Okay, this person crosses the center line. It's punitive. So this person turned left in front of me. That's a violation of law. It's punitive. So some people did that, and it made them hard to settle and slow to settle.
Yeah, it would seem to me it would too, because you have coverage issues, and then what's covered and what's not. And
yeah.
I can see using the threat of punitives to get more on the compensatory side,
Yeah.
so because they know if they miss it and go to trial and they don't settle within the policy limits, the insurance company on the compensatory side, they're subject to a bad faith claim, and then the consequential damages of that is the punitive damages against them.
Right.
But it's got to be done in the right case, right?
Is
that your feeling?
Yeah, it's got to be the right case. Well, yeah, sometimes the punitive claim can backfire against the plaintiff.
Tell me about that.
Well, I remember a case I had one time, not too long ago, where there was a claim of punitive damage, and it was appropriate in the case insofar as it was drinking. It was a car accident case, too. And there was evidence that the defendant was drinking. She was drinking. She had drink, but she only had one drink. But she had ingested alcohol. The jury, and so they danced on that drink. And here's what happened: is she had worked. She had come home. I don't know what she did. I don't remember. But she got home. She was doing housework. She poured herself a glass of wine. I was going to say bottle of wine. She poured herself a glass of wine. Was drinking that glass when her kids came home from school. Her kid needed to go up to, I don't know, Walmart or somewhere. And so she got in the car and took her kid up there. While they were in the parking lot, they had an intersectional collision with a car that was coming down one way. She was going the other way, and they bumped each other. And so the jury heard her talk about how much she had to drink, and it was about an inch of a wine, and they didn't believe that had anything to do with the accident. And so they gave them almost nothing. Now, I will tell you, it was a very conservative county. But had that happened somewhere else, it might have been a good strategy. It was not a good strategy in that case, and it hurt them. But That's fairly rare. Normally, if you can get punitives in, as you know, you can ask for a lot of money. Tell me about situations you've had where you have had cases where you've had punitives in, and you either submitted them or decided not to submit them.
Well, that's the one tactic you can use is have punitives in your case, and then if the defendant does not ask for bifurcation on the punitive evidence, you in your case in chief, you can put in reckless disregard or conscious indifference types of stuff, and maybe you can broaden the relevancy definition of what should come in a trial, and at the end you decide whether or not to submit to the jury or not, or at the end the defendant will make a motion to say you have not met your burden to submit punitive damages to the jury. And then I'm going to turn around. My question to you is going to be, does that work? But let me just finish answering your question first. So I've tried cases with both. And I had a case one time I tried, and I tried it with punitives, and the offer in the case, it was about $500,000 in limits. They offered me about $200,000 to $250,000, I don't remember, during trial, nothing before that. We tried it, and I remember Evelyn, I won't say the last name. Well, I'll say it's public. It's Evelyn Goodlow. I'm still friends with her family. This is 20 years ago or 15 years ago. She's a great lady. And the jury came back for $625 compensatory, $250 punitive. And the $250 wasn't covered by the policy, obviously, right? So then we went to the Court of Appeals and the Missouri.
Neither was the $150 on the excess of the compensatory.
Yeah, that's exactly true. I argued that to the Missouri Supreme Court, and on a hearsay issue, on a multiple hearsay issue. It wasn't coverage issue. Anyway, we won the case on appeal as well. We kept the verdict, and they ended up paying like $1.1 or $1.2 million on a policy that was it was a $500,000 policy.
Okay, so hold it. You got more than the verdict from the insurance company. What was it, a bad faith issue or
bad faith and more than verdict and more than the coverage, because I had interest after I won in the Court of Appeals and then went to the Supreme Court.
So let me ask you this: wouldn't you think that if you had a $900,000 verdict, maybe that was all interest, but if you had a $900,000 verdict, wouldn't they prevent any bad faith claim by simply paying the verdict?
They would, but they wanted to appeal, so they appealed it, and then they lost on the appeal.
Got it. So
I remember Mike Wolf I was arguing to the Supreme Court, and bless his heart, Mike Wolf is asking me questions, but he's looking at Judge Limbaugh, and Judge Limbaugh's looking at him asking me questions, and they're both asking me questions and looking at each other, and no one was talking to me. It was really funny.
Oh, funny!
But they were
between themselves.
They're two brilliant jurists on the bench in that argument.
Who was the second one? Wolf and who? Limbaugh
and Steve Limbaugh. I think.
That's funny.
I think that's who it was. Anyway, but yeah. So remember, on the plaintiff side. If you're adding, there's times I don't like adding punitive damages in a car crash case. It's just I never heard, we've never talked about this till we got on this. I agree, it slows it down. Because then they got to worry about coverage and whose coverage. Is there private counsel? Blah, 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 blah. Now, I think that later you can do that if you get some really good meat and potatoes. They were really drunk, or they did this, or it's their third DUI. Then you add punitives, and then you appropriately put the pressure on. But what's the line of punitive damages? There's negligence. There's kind of bad. Yep.
Well, let me ask you this. I want to back up real quick for our listeners because there's one thing I'm going to forget if I don't ask.
Yep.
Let's go back to that case you were talking about, the 1.2. Did they pay that because that's the judgment amount, and you ended up with a paid punitive amount?
Yes.
What do you do with the taxes?
I had to pay half the.
Tell what that means.
Well, so if they paid that whole amount, now usually what you have to do first is you have to get an assignment of the bad faith claim from the insured defendant, and then you sue the insurance company. But they paid the whole thing without making me do the however many steps that is.
Yeah.
I wrote a letter to the Attorney General's office at that time, and I said I got this punitive damage award, and you guys are doing this. And at that time, paying half the state was a newer statute.
And tell what that statute is.
It says that you have to pay, and I don't have the site, but you have to pay half. You don't have to look it up. Either way, you have to pay half the punitive damages amount goes to the state, and it goes to the Tort Victims Compensation Fund, I believe.
I thought so too.
And which is great. And that talc verdict that Eric Holland and Mark Lanier got paid a lot of money to the Tort Victims Compensation Fund and to the legal services. I'm on the board of legal services, and the Southern and the Western and the Eastern Missouri Legal Services got a lot of money to help a lot of people. So thanks to Mark Lanier and Eric Holland for their work. But yeah, you got to pay the half. So I did a letter to them, and I said, after the attorney's fees is this, and this is how much you should get. Is that right? And they said yes, and I sent them a check, and they got it.
That was that. Okay.
My client got the rest of it.
So that's a key to remember, though, because a lot of times if you end up with a punitive damage award and a compensatory award, you settle it for something other than those two amounts so that you don't have to pay the punitive.
Right, but here they took it all the way. I had a final judgment affirmed on appeal at the end of the day. There was it was a final judgment with a punitive component, so you couldn't parse that out. You couldn't sneak that into a compensatory and try to avoid that.
Yeah, sometimes it's a good settlement tactic though, because I know of that 250 punitive, you're going to only get 125. So if you can offer a little more than that and get the person to settle, then that's good.
That's right. Why put all your time and energy into a punitive verdict when you're going to have to pay half that to the state when you can take the same energy in the compensatory? Which turns to the question I wanted to ask you. Can I ask you a question?
Yeah, but you were in the middle of something when I interrupted
Tell me.
I wanted you to go back to that case you were talking about. So you were talking about, after this $1.2 million case, you were talking about going to a different case and making a punitive claim, and then I think you were going to tell us that you made a decision to submit it with us.
Oh, yeah. So I've also had cases where I have really bad conduct, and I also do these sometimes I've done a lot of class action work and consumer fraud work. The Missouri Emergency Practices Act has its own intentional component of damages. Sometimes if conduct's intentional on the Fair Labor Standard Act or some other things, you get double or triple value damages. There's some antitrust. So I don't want to. I know that can be a whole nother podcast. I don't want to go on and on, but yeah, you can make an intentional decision to saber rattle and scare them with punitive damages. Then you can get then you get the discovery on this, other incidents, evidence of recklessness, all these other things. I like to do this also sometimes I've had cases against trucking companies or other institutional defendants where their failure to supervise or failure to hire, the conduct is terrible. They got drunks driving from them and killing people or people on drugs, and I'm not, it's just terrible. And they know it and they don't do anything about it or whatever.
We're going to see more and more of those because there are no truckers you can hire.
It's hard.
We're going to see a lot of those.
I settled a truck crash case. You were making a joke about these articles on the wall around me.
Yeah.
One of the articles on the wall, I'm still bound by a confidentiality agreement about, although I can tell the amount of the money, I can't say anything about the drugs this guy was on. It was crazy.
God.
But anyway, so there are cases very appropriate for punitive damages. But what you can do is you can use that threat of punitive damages and plead punitive damages to get all the discovery in it, get the things. You can go into evidence. You can, at trial, you can put on your evidence. You can put on evidence of recklessness and conscious disregard. But at the end of the case, you can say, I'm not submitting MAI or Illinois Pattern Instruction blank on punitive damages, not submitting it.
Yeah.
And then we're just going to go to trial on the compensatory damages.
Yeah.
And I've done that before too.
Generally,
So my question was sorry, does that work on the plaintiff side?
It depends, but yeah, if it's really punitive, yeah, that can get a jury riled up. And then I should tell this story. And then it can get a jury riled. And then you have the jury coming back and they only could put compensatory damages. So what does that mean? It means it's all covered.
It's all covered.
Means there's no 50% tax to the state. I had a case years ago with John Simon where the jury was so mad after we talked about punitive damages the entire trial, they wrote in punitive damages. So
I'm the verdict director when they couldn't, when there was no space for it.
Fortunately, that went away, but only the punitive portion did, but it affected the compensatory too, and it does raise it. Sometimes though, you got to know where you are.
Can I ask you this? I'm sorry, I interrupted you.
No,
Tell
I'm
me
just
you
going to say
mean
you got to know where you are, and if you're in, a St. Charles County or a Lincoln County or someplace like that where people don't like to punish, you may be the one getting punished. So you have to think about what the case is and where it is.
You can't overplay your hand.
Right.
And you can't make...
That's right.
Back to your other story. And you got to, to me, I try to underpromise and overperform, And so on these punitive damages, you want that jury going, what? Oh, no, he has that too. He has that too on the plaintiff side. So by the time you're closing, they're like, I know you suggested punitive damages, but there was, you walked the walk. You didn't just talk the talk. You don't want to sit there, like in your other example about a half a glass of wine, people screaming and yelling about drinking, and you have a mom who took a half a glass of wine after a long day at work and had to drive her kids somewhere. That is not
I'm
appropriate.
sure she eventually finished it, but before she drove, it was only a half.
I tried a case one time where my plaintiff was drunk, and she was walking across a road, and she got hit by a car, and we admitted she was drinking, and I thought, stupidly, that I was like, hey, she was responsible. She went and drank. It was her neighborhood bar. She left. She walked home. She looked both ways. She was at a light. She crossed. She thought it was clear. She crossed and got hit. I was wrong.
Really?
I got defense verdict in 45
then.
minutes.
Where was it?
City.
What?
I thought you in your local tavern in the city, I thought you could drink and walk home.
I thought so too.
But apparently
especially if you're at a crosswalk.
Yeah, and there was bad shit.
At the corner.
Yeah. I was wrong. Because you know what? It's funny, drinking, and I know we're on punitive, but drinking and drug use, people want to judge harshly on that and DUI laws, and they should, and it's dangerous and it kills people. But then in their lives, they drink or smoke weed or stuff at home, and so it's a little. It's a hard issue to parse out a little bit.
It is a hard issue, and nobody really tells you their general thoughts about it.
No.
What I really found out people tell you their general thoughts about it is I tried a case not too long ago where my guy had a little bit of road rage, and he flipped the bird to the other guy. Well, that makes people mad. Oh, the jury was mad about that. It had nothing to do with anything, but he said he did it, and they did not like it. They hated him the rest of the trial. Fortunately, the plaintiff
And then how many people on that panel have never flipped the bird at something?
Exactly.
Which is your point.
I probably did it before I left the room. Hey, let me ask you this.
Oh, can I finish my question?
Yeah. I'm sorry.
So let's say the plaintiff in a case does all this punitive damage evidence, and then you're in a instruction conference and they say, I'm not submitting punitives. Is there any motion you can make, or is there anything you can do and say, that's bogus, Judge? That was false. That was false. They put in all this stuff and it's not relevant anymore. So you've made erroneous evidentiary issues, and I want a mistrial.
You can file that. I've never seen it granted. I have filed repeatedly when that has happened. I have filed a motion to remove the issue from the jury as an instruction.
Like a withdrawal instruction, like a 2.07 or 3405 or one of those. Like that withdraws insurance, but yeah.
Yeah, but the 2.7 or whatever. But some judges have given it for me and some have not. In any case, I always argue that the plaintiff has told you, they're going to have punitives, or they're going to do this, or going to do that. But you can see from these instructions, the judge has not submitted that to you. I argue that, and I've gotten away with it. I think it's appropriate to argue it.
You're talking about the instructions, and you're commenting on once they said an opening.
I think it's appropriate.
I think you can do that, because they said they were going to show this to you, and they haven't.
But here's the thing.
But then you walk into that because they said, well, it's here.
That's
because there's all this bad stuff here, but we want it on the compensatory, folks.
Well, and I'm not sure.
Could I get up and say on my second half of closing, I could say, yeah, but we don't want to give half the money to the state.
No, I don't think you can say that. However, I think you can say this. I think you can say there's not two lines here for punitives, and you cannot give damages to punish somebody. But let me tell you what, this is an aggravating factor. I mean, and so that's what I have to remember to tell my clients. I may not believe this is punitive, but it sure as heck aggravates the jury and aggravates the verdict and makes it go up. And so that's the issue. Maybe you can't maybe the judge takes away from you punitives because the person is on the phone when it's not illegal in Missouri. Maybe the judge takes away from you a submission when somebody's going 20 miles an hour over the speed limit because they're just speeding, and maybe that doesn't rise to the level of punitives. But it sure is an aggravating factor. And I don't think you should underestimate the harm of those aggravating factors.
Thank you. This is great. Let me ask you another question. Do you file a motion? To preserve your error, do you file motions to eliminate or prevent punitive damage type of evidence? And at the end of the case, do you do a motion to strike punitive damage from going to the jury and to prevent that?
Yeah, I do both of those things. And I file a directed verdict motion on punitives each time into the plaintiff's case.
Do you move to bifurcate punitive damages too? Or is that's a tough...
I do most of the time. Depends on the case, but most of the time I move. But here's the thing,
how do you do on those?
Well, I mean, they automatically bifurcated, but all that means so just so people don't know this.
Yeah, tell me that.
It's not really bifurcated. You have one voir dire, you get to ask all about punitives and that. You have one submission of evidence, you have one. The only thing that happens is you send the jury out on the regular verdict. If they think punitives is there, they're going to raise that compensatory verdict anyway. And then they come back out, you read them the punitive instructions, you have a closing argument or sometimes additional evidence for the punitive section, and then you send them back with another verdict to fill in the number on the punitives if they found that punitives are appropriate.
So what you're saying, and I hear what you're saying, but another way to say what you're saying is sometimes the bifurcation might work against the defendant because they've already jacked up the compensatory, and then you come back.
That's right.
And then, now in that bifurcation, though, isn't it true that you don't put on evidence of the company's financial wherewithal? That's the only other evidence on the second part of it.
Generally. Unless there's something punitive, you haven't gotten into the compensatory part of the case. And why in the world would you have that? So I get new evidence in that portion of the case, like how pitiful it was that this guy was and what he was going through in his life and that sort of thing. I can get that evidence in because
exculpatory type of stuff.
Yeah.
Don't punish him. He's had a tough day. He had a long day.
And I've seen it go different ways. I was a plaintiff in a case where I decided to somebody bifurcated. I don't remember which one. And they went out and they gave me big compensatories. And they came back and gave me punitives, but they weren't very big. And they just said, we didn't want the company to go broke. So they knew it was insured.
Right.
And then they gave me smaller numbers for the company. Isn't that funny?
They knew that the insurance would cover the compensatory, but not the punitive.
Yeah, smart jury.
Yeah, that was smart.
Yeah.
That was smart.
So I've seen that, and that's not what you normally expect. If they're mad enough to give punitives, you expect the punitives to be punishing. But this was the other way around, which was fine with me. Money's money.
Right.
I was the plaintiff in that case. And then
Right.
in defense cases, you kind of see them do the same thing, but I tend to think there are some good cases, and you have to think about it, where I'll send them out with both. Here's the compensatory, here's the punitive, and then I argue about that in other words, sometimes I'm thinking now about not bifurcating.
Is that when the plaintiff's overreaching? Like it's looking.
When I know I'm not fighting fault. It's when I know the jury's going to give punitives, and I know I'm not fighting fault. And what I want to tell them is this: we need to compensate this plaintiff, and that's a lot of money. But you don't need to punish these employees of this company. This company should not be punished.
Do you have any? Is there a tension there for you because you know that the compensatory is covered and the punis aren't?
Well,
what's the tension?
Yeah, the tension for me, and maybe this is the wrong way to think about it. The tension for me is I got to keep those punitives down. That is my number one. I want those punitives gone because that's my number one priority. My priority is to my client.
Right.
And if there's an excess compensatory damage claim, then I got somebody else who can pay it. But I know this guy here, who is an 9 to 5 worker, is not going to have the money to pay it.
I've done the punitives, in trial or feigned it and not gone to the jury. But the other conversation you have with your client on the plaintiff side is to say, listen, I know you're mad and I know this is bad conduct, but it's smarter to leave this as a compensatory claim because we're going to be able to settle your case, get your money, move on in life, and the punis half go to the state anyway. What's your net going to be out of that? That kind of stuff. And so I try to always have a conversation with the client about that. I've never really had a problem with that. I was thinking about client communication on the other side when you were talking about yours on punitives. But
I'll tell you what the hardest communication is when I have a punitive damage claim and I have an insured and I want the insured to get personal counsel. And they will not do it, and they will not do it, and they will not do it. No, I want you. And I'm like, no, you need personal counsel. So what I have to do is do all the things that personal counsel will do for them because that's my job.
So in one of the cases in the case that I tried with punitives I was talking about earlier, where we got the $250,000 in punis, and in other cases, in the deposition of the defendant, I asked them questions like, do you know that there's been, so I do interrogatories on reservation of rights, and I do interrogatories and discovery on whether or not they have personal counsel.
Yeah.
So I'm saying, are you aware, and I remember this deposition forever, are you aware that we've alleged punitive damages here? Are you aware that
half the time they say no.
They don't know.
They do know.
Or
they don't know what that means.
Or do you have another representation? Do you have another lawyer? Have you made a demand on the insurance company to settle this case within the policy limits to avoid personal liability on you? Are you aware that punitive damages many times are not dischargeable in bankruptcy?
Yeah. People always ask that, and the insured always knows, and the insured always denies it because they didn't understand it to begin with.
It is hard to get people to understand that.
It's so hard. But there are letters. There are always letters there. So the problem is you've got an insurer privilege. People don't assert that. I never turn over reservation of rights letters because I think I represent the insured. It's insurer privilege. So I say, I don't have any problem with you calling the company. Talk to them about it. I don't want to.
You let them call the company?
Yeah, well,
they're represented.
It depends on what it is. Well, if the company has a problem with the reservation of rights, they need to assert the insured privilege and get the insured's approval to release it. Right. But I can't tell the company all that.
No.
I can just object for the insured.
Right.
But the company usually knows it. Just
do you get insulted when a plaintiff's lawyer tells you something like, there's this punitive damage claim. Have you told them that you're laughing because you know where I'm going? Do you want me to ask the question?
Yeah, ask.
No, just what you say, because I've had other lawyers say, "Don't tell me what to tell my client." So I say, have you told them that there's allegations of damages here that are not covered by the policy, and that they will be personally liable for that, and that's may not be dischargeable in bankruptcy?
And so you do
you get mad?
At this stage of the game, I kind of just laugh. Because I want to say,
meaning you've been doing this for 50 years now.
Do you think
how long have you been doing this?
35.
All right, sorry, go ahead.
And you just want to say, do you think I'm brand new?
This ain't my first rodeo.
Yeah, I'm not.
What do you say in Knoxville? What would you say that?
In Knoxville, did you say?
Yeah.
Yeah, this ain't my first rodeo, or all kinds of things we could say. But of course, we've told the insureds that. Of course, we've written those letters. Doesn't mean the insureds understand them, and that's what I worry about. So usually I have a personal meeting with that person, and then by that time, when I say you really need personal counsel, no, you're my personal counsel. I don't need personal counsel. That's tough. That is tough.
I just settled a case. It'll be in the Lawyers Weekly for we just settled a case for a poor guy for $2 million, and as soon as I sued the defendant, I had the guy's his son was a lawyer, and he called me and he said, if you make that policy limit demand, I'll be writing the letter. So they knew exactly, and he had counsel, and I've had other counsel call me.
That's fantastic. It makes my life so much easier.
That's exactly right,
and your life easier too.
We just want the letter written that the demand is settled within the policy limit, so everybody's covered. Because if people don't know who are listening, that's a step in the later bad faith case. Is that part of the elements in a bad faith case? Is there's a policy limit demand? The insured requested that the insurance company settle within the policy limits. The insurance company refused, etc.
Yeah.
That can be one of the elements.
That's right.
Yeah.
So, okay, I have a question.
Yep.
Is this punitive? Again, I'm going back to car accidents. We could also go to negligent hiring, anything with negligence. So you have to make a claim for negligent hiring. You've got a claim. This guy had a criminal history. You didn't check it. You didn't know it was there. So that's your claim for negligence. So here's the deal. You had a duty to check. You didn't check. That's negligence. He did this. Now you're liable for his, for that. All right. Is that punitive if that is also the identical basis of your claim to begin with? In other words, don't you need something more against somebody when you're alleging negligence than the negligent act you're complaining of? Car accident's the best way to sell it. To explain it. Let's say you've got you ran the stop sign. You missed the sign. You ran the stop sign. And you sue them for negligence. Clear negligence. There's a clear allegation of negligence. Can you also get punitives on that with no additional information?
Objection, compound question. Form. So that the answer on the stop sign is no. I think that's the same.
What about speeding?
Well, but if you're going through a series of 4 stop signs in the city and you're going 80 miles an hour, that's punitive.
Got it.
So that's my gut.
I think you're right. I think that's not just running a stop sign.
But what's the difference between
disregard for stop signs?
Whatever that word is, disregard for the safety of others.
That's right.
So not rolling one stop sign
is not just.
But
that's a mistake.
I've seen more people running red lights lately. It's crazy.
Oh my gosh!
It's
downtown
crazy.
Is nuts.
Downtown, and so I pause. I don't even go.
I drive like an old woman.
But what about drunk driving? What about drunk driving? Now, drunk driving, it's the same legal violation, but to me, that drunk driving is something more.
I think it is something more because I don't think that's the negligence. You weren't negligent because you were drinking. You were negligent because you happened to be drunk when you did this violation of the rules of the road.
You also failed to yield the right of way or do a stop sign or did something else
and
to
on
wreck.
top of that,
and you were drunk. Mm-hmm. And you were drunk.
Yeah.
And you
or
were
on
drunk.
drugs or on whatever.
Uh-huh.
And now the question is, what about the phone? You failed to keep a careful lookout you were looking at your phone, but that's not against the law? In Illinois, maybe.
I don't.
I know I struggle with that all the time.
Well, I'll tell you, I happen to now have a self-driving car.
Dude,
and so
really? You are
when I
so
go
fancy.
home, no, the point of this is to brag about myself. No, but I'll turn it on. I'll turn it on and I'll go home on the highway because it's a great place to do it. And you're in one lane, and I can do different stuff and call and stuff. But I'll tell you, it lets me look at other people in other cars. Everybody's on their phone. I've seen this more in the last 2 years. People
talking or texting?
On their phone, looking at it, mostly reading their phone, reading Facebook on the way home. I mean, but everybody's doing that, I think.
I am on the phone.
It's keeping me
in
business as a plaintiff's lawyer. People are rear-ending each other all the time, every day on Highway 40. There's a wreck. So yeah, I don't know. I got a case right now, and I did work on it today, and the injuries are terrible. And this guy admits he was on his phone. And to me, why do I care about getting a punitive? Why don't I? I'm thinking that I should put that. I should complain about it and make a deal about it, but that should be part of the comparative. As aggravating circumstances.
Well, I'm telling you, if you talked about the phone and you didn't submit punitive, and you talked about the phone, that would up that compensatory damages claim. But I'm not sure if you said, I'm going to punish this guy. I want you to punish him for doing this. I think some of them would say, well, wait, I don't want to punish him. We just need to teach him a lesson, which they think is something different. So let's put it in this pile, and not
especially if they walk in as smart defense lawyer. It's a rear ender on 2-7.
Yeah,
smart defense lawyer is going to admit liability.
Oh, absolutely.
And then you walk in and say, "We're taking responsibility."
Right.
What are you talking about?
Right.
But it's these cases, the real cases when you get these punitive damages to me are when they don't accept responsibility. And you can look the jury in the eye and say, if you don't do punitive damages here, or you don't give a hit, if you don't hit them. I've said this before in compensatory cases. They say, if you only give them a little bit of money, just give them zero. We don't want anything. Because they're conscious of the community. You need to send a message what you're allowed to do.
That's a punitive damage argument. You can't argue that.
Well, you can a little bit.
You cannot argue send the message.
Do you know what the seal on the state of Missouri says? Above in every courtroom, let the voice of the people be the supreme law. So you can tell me. Maybe you're the conscious of the community. It says it right there. You're deciding the standard of care in this community today. You decide whether or not it's good, it's right or not. So unless there's a big verdict here, unless you award the full value of my client's injuries, they're going to go. He's going to drive from this courthouse and drive the same way.
I would object.
Can I say that?
I would object.
Because it's good.
But you might get away with it.
Because it's good.
No, I would object because, I think maybe you could say it. I got to think about that. But you can't send a message that he can't drive that way anymore.
Okay, I won't say that. Can you edit my closing? I'm doing it the night before, so you won't have time.
I'll be doing this the back.
And how do you what do you say? So you say, you already said it today, I know we're going long, but your message is, we don't need to punish him. We took responsibility. Right. You can award, but there's no reason to punish him.
Well, it's not him. It's the company. The company is where they want the punitive.
Right, of course.
So
that's
why
where I
are you
always
punishing the company for the actions of the employees?
Do you put in? Can I ask another question?
Of course.
Do you sometimes put in subsequent remedial measures, your own, to show that you're responsible?
It depends on what it is, but yeah.
So do you fight the motion to eliminate in the beginning and then do it and then stick it in yourself? You don't need to tell me all your tricks. No, you don't want to tell me, do you?
I have done just exactly what you said, and I have also fought it, wanting to lose it, so it could come in for a different purpose. But then I have an issue on appeal if I lose. I do that a lot.
I took this trick from. Do you know Mark Wallace and Mark Bronson?
Yeah,
smart lawyers,
fantastic
great
lawyers.
People. You know what?
Really good lawyers.
You know what they do?
And fun. I love
and fun. And I don't want to. Let me share this. We're sharing tricks. You know, the other thing, so if there's a subsequent remedial measure, I think I learned this trick from them, is you just get up and voir dire and you say the company never did anything about it. Would it make you mad if this company never corrected the problems, blah, blah, blah? And you're like, fine, keep it out. Then the jury thinks that they never did anything about it. And then the first evidence the defense does is, here's our new policy.
Yeah. That's
Have you ever had that done to you?
No, I haven't.
Is that smart, or do you think that's?
I think it's a great idea.
Yeah, that's worth listening to this podcast for.
Yeah, that's right. I think that's a great idea.
I think we've run out of time. Thank you very much for doing.
This has been a fun one, Gary. I don't know how much we taught people, but it sure did make it on my mind for the next one. How about you?
I think it's great. I think you need to look. I think the takeaway too is really think deeply about what juries are going to ask, and don't think about it yourself. Ask other people. Ask your spouse. Ask your friends about whether they think, because what you think is egregious, you may be, or not egregious, you may be drinking your own water.
That's right.
Get out of your own head and focus group it or do something.
That's right. And the other thing is, do not look at your phone while you're driving and listening to our podcast.
Absolutely.
Just let it ride.
Right. Thanks, Debbie.
Thank you, Gary.